Namaskar. Today, we're diving into a crucial concept for law students, the effect of transfer under the Transfer of Property Act, 1882. This principle is the backbone of how property rights move from one person to another. Think of it as the basic rulebook for property transactions, ensuring clarity, certainty, and preventing disputes. Mastering this is like learning your ABCs before writing words. It's foundational for any legal career. We'll break it down with relatable examples and practical insights. By the end, you'll have a clear grasp of how property transfers work in law and in life. Let's get started. At the heart of property transfer is a simple maxim: accessorium non ducit, sed sequitur sum principale. The accessory follows the principal. In practice, this means when you sell a house, you're also selling its doors, windows, and built-in fixtures, even if not listed separately. Sell a cow, the unborn calf goes with it. Sell an orchard, the fruit goes too. The law ensures that all essential parts and attachments transfer with the main property. Imagine buying a car without its engine or a phone without its battery. Illogical, right? This principle prevents such confusion. It sets a default expectation. The main thing and its accessories move together. Both buyers and sellers benefit from this clarity. It's a rule rooted in logic, fairness, and everyday experience. That's why it's a cornerstone of property law. This principle is codified in Section 8 of the Transfer of Property Act, 1882. Unless stated otherwise, a property transfer includes all interests and legal incidents the transferor can pass. Legal incidents means things attached to the property, like easements, rents, trees, or fixtures. Buy land? You get the land, access rights, future rents, and everything attached. Buy a house? You get the doors, windows, and permanent fittings. The law assumes a complete transfer, so you don't have to list every detail. This default rule streamlines transactions and avoids disputes. Section 8 makes the maxim legally binding and practical. But the law is flexible. Section 8's rule applies only if there's no contrary intention. Parties can agree to exclude certain items from a transfer. For example, if a seller wants to keep an antique chandelier, they must state this in the sale deed. The transfer document is key. What's written there overrides the default rule. Clear drafting is essential to avoid misunderstandings. If an accessory is excluded in writing, the buyer can't later claim it. This flexibility lets parties tailor deals to their needs. The law's default is convenience, but the parties' agreement is final. Always read and draft transfer deeds carefully. The Supreme Court has affirmed this principle in landmark cases. In Sen Sudalai Muthu Chettiar v Palaniandavan, 1965, the court ruled that machinery fixed to an oil mill was transferred with the property, even though not listed separately. The court held, if the transfer deed doesn't exclude an accessory, Section 8 applies. This ensures buyers get all essential parts, unless the deed says otherwise. The judgment reinforces that the law presumes a complete transfer. It protects buyers' expectations and provides legal certainty. Lawyers and judges often cite this case to support broad, inclusive transfers. The principle stands strong in both law and judicial practice. It's a trusted rule for property transactions. To recap, when property is transferred, all its legal incidents go with it, unless specifically excluded. This is the essence of Section 8, and the maxim, the accessory follows the principle. For exams, explain the maxim, connect it to Section 8, use simple examples, and mention exceptions. Citing S.N. Sudalai-Muthu Chettiar's case shows depth in your answer. Understanding this principle is vital for your legal foundation. The law's clarity here helps build trust in property transactions. Keep learning, stay curious, and remember, strong basics make great lawyers. Thank you, and best wishes for your studies and future.